The Leader of the Opposition.
Thank you, Mr Deputy President. I rise to lead for the Labor opposition on the Environmental Planning and Assessment Amendment Sydney Drinking Water Catchment Bill 2017. Let me say at the outset that the Labor opposition will be supporting the measures in this bill that secure the supply of electricity to the state. The problem the state is facing is largely one of the government's own making, and I will develop this theme during my contribution. The object of the bill before the House is to amend the Environmental Planning and Assessment Act 1979 and the State Environmental Planning Policy Sydney Drinking Water Catchment 2011 to do three things. Firstly, to validate the development consent granted on 21 September 2015 in relation to the Springvale mine extension. The Labor opposition wholeheartedly supports this measure. Secondly, the bill will validate any other development consent that would have been valid under the test, as the bill purports to clarify, quote unquote, or in reality will have been changed by this legislation. And C, the legislation claims to be clarifying the application of the neutral or beneficial on water quality test, the so-called Norby test, in the case of a development application for the continuation of development under an existing development consent relating to the Sydney Drinking Water Catchment. But in reality, it is not clarifying. It is changing the law. It is changing the catchment set. It is changing the authorising legislation in 34 capital B of the Environmental Planning and Assessment Act. The Labor opposition does not support the second and third measures contained in the legislation for reasons I will outline, and we will have amendments that seek to remove those from the bill. It's useful to understand how we came to be in this situation. Springvale is an underground mine about 15 kilometres northwest of Lithgow, near the Blue Mountains where I live, so I'm happy to declare that interest. It undermines the Nune State Forest on the edge of the Blue Mountains World Heritage Area. And it mines 4.5 million tonnes of coal per year using longwall techniques and supplies coal, as the Minister has outlined, to Mount Piper Power Station as well as to Port Kembla Coal Export Terminal. In recent years, as the Minister has also outlined, several other mines in the area which could have supplied coal to Mount Piper have closed, as has the Wallerawang Power Station, and Springvale is now the only local source of coal for Mount Piper, and with the power station is the largest local employer. Roughly, the mine and the power station employ 300 full-time equivalent staff each, 600 in total. And of course, that's without taking into effect the so-called downstreaming effects of the expenditure of local incomes in the local economy. Taking a conservative estimate, if those jobs were to be taken out of the local economy, the direct hit for local businesses would probably be something like $15 million, and the multiplier effect could be as high as $100 million. On any analysis, not only devastating to the social fabric, but devastating to the local economy. In 2006, the mine was instructed by the Environmental Protection Agency to begin transferring wastewater to Wallerawang Power Station for the treatment and reuse to avoid dumping it in the upper catchment of Sydney's drinking water and the Blue Mountains World Heritage Area. When Wallerawang closed in November 2014, the water treatment plan was decommissioned and the environment protection licence for the mine was altered to allow the water to be discharged instead. Springvale is now licensed to discharge 19 megalitres of water from its discharge point into Sawyer Swamp Creek and the Cox's River, the second largest stream flowing into the Warragamba Dam, which of course supplies Sydney's drinking water. This water comes from the coal seams being mined. It's highly saline and contains heavy metals as well. And Springvale mine has been, on a number of occasions, found by the EPA to be in breach of its licence for exceeding limits on various forms of discharge, not only for saline. The mine sought and received approval to expand in 2014-15. Because of its location within the Sydney Drinking Water Catchment, the mine was subject to the provisions of the State Environmental Planning Policy Sydney Drinking Water Catchment 2011, the so-called catchment set. which prohibits the granting, in clause 10(1), which prohibits the granting of development consent unless the consent authority is satisfied that the proposed development will have a neutral or beneficial effect on water quality, the Norby test. The environmental assessment for the expansion found that it would cause a significant increase in the salinity in the swamp and creek immediately downstream, and that the discharge would increase the salinity of Warragamba Dam by up to 6%. And that's from the Planning and Assessment Commission Review Report, Springvale Extension Projects, May 2015. In June 2014, the New South Wales EPA's comment on the environmental assessment for the Springvale extension said that the Centennial had failed to adequately assess the impact of the mine expansions on water quality, and said, quote, "This is a major concern to the EPA," unquote. The EPA described the contaminant load as a major issue, stating that the potential salt load alone, 7,500 to 13,000 tonnes per annum, is, quote, "extremely large for a freshwater system," quote unquote. And that can be found in the New South Wales EPA letter to Howard Reid on the 3rd of June 2014 at the Department of Planning and Environment. The Sydney Catchment Authority said at the time that the project should be refused consent unless a requirement were imposed that the discharged water be treated. I pause there. It was quite obvious that something like a water treatment plant would be needed even at that point. Without this requirement, the mine would not achieve the test of having a neutral or beneficial effect on water quality in the catchment. It would be downgrading the quality of the water flowing into Warragamba, making it saltier, adding heavy metals to it and contributing to the toxicity of the aquatic environment, which of course is quite delicate. The approval was granted in September 2015 with a condition that by July 2017, that is to July gone just now, the mine had to significantly reduce the salinity of the water it was discharging into the Cox's River and reduce the acute toxicity of the downstream environment from the measurement, which was 20%, I recall, above the allowable limits set by the EPA. And they had to progressively reduce that. The mining company agreed to the timeline, but it was quite clear within a year or so that there was no other way to address that development consent without constructing an extremely expensive water treatment plant. And I think the company, Centennial Coal, thought not unreasonably that it shouldn't shoulder the burden of this alone. Centennial and the operator of Mount Piper, Energy Australia, were in this together. Although the two companies obviously had some difficulties working out the financing arrangements, nevertheless they did agree to a joint venture project, and they have obtained planning consent for it, as well as, I understand, raising the necessary finance. However, by July 2017, construction had not commenced, and so, again, as the Minister has outlined, the proponent, Centennial Coal, the operator of the mine, had to approach the regulatory authorities to seek a variation to extend out the time to construct the water treatment plant until June 2019, and that was granted. The Planning and Assessment Commission made it clear in granting the approval that the discharge into Sawyer Swamp Creek and the Cox's River was to be an interim solution only, and that action must be taken to treat the water and send it to the Mount Piper Power Station instead. As I indicated, Centennial Coal did gain development consent for the plant, but it hasn't commenced construction. Pretty much soon as the Planning and Assessment Commission, however, had approved the consent, the environmental group For Nature lodged a challenge against the mine approval on the ground that the Planning and Assessment Commission had failed to correctly apply the crucial neutral or beneficial effect test. As the Minister outlined, the applicant was unsuccessful in the Land and Environment Court before Justice Pepper, but on appeal to the Court of Appeal on the 2nd of August, they were successful. They persuaded the court unanimously that their construction was correct and that the construction contended for by Centennial was not correct. The Court of Appeal found that the Planning and Assessment Commission should never have approved the proposed expansion to the Springvale coal mine because the law prohibits the approval of developments within the Sydney Drinking Water Catchment unless the consent authority was satisfied they would have a neutral or beneficial impact on water quality. And of course, the crucial question is, in making that comparison, where do you start? And of course, Centennial proposed to the PAC, supported, as I understand it, by submissions from the Department of Plan and Environment, that you compare the proposed new mining activity, or extended mining activity, with the current activity. Whereas the Court of Appeal found that that was not correct. It's not quite correct to say the Court of Appeal found that the test was to compare the proposed new mining activity with no mining activity, but certainly in assessing what the impact on the water quality would be, the decision maker had to take into account that the mining consent was not permanent, and in fact was likely to come to an end, and in fact was coming to an end very shortly. And so there was a range of considerations the decision maker had to turn his or her mind to, and did not. In the wake of the Court of Appeal ruling, the matter was sent back to the Land and Environment Court. Now, interestingly, for some reason, Centennial Coal thought that the planning issues could be sorted out at that level, and I think at some stage the successful applicant thought so too. But it was quite clear within a reasonably short period of time that that was not going to fly, and that although the court had some discretion about how much time the mine could be given, ultimately the Land and Environment Court really could only decide at what date the mine should be closed. And of course that uncertainty was causing a terrible toll on the people whose livelihoods was being affected, but it was also creating uncertainty in the electricity market. Not because there was a shortage of supply, but simply because of the risk of shortage of supply. And at this point, when it was quite clear that the parties and the court were not able, through the court process, to work it out for themselves and for the state, a responsible and responsive government should have reached out to the parties to the litigation, to the affected workforce and the community in and around Lithgow, the operator of the Mount Piper Power Station, Energy Australia, to get everyone around the table to see if a solution could be developed and put into effect in short order. Those things should have been explored by the government, and it did not do so. I know the government spoke with the two companies, but not to those who had brought the case, not with the affected communities or their representatives, the council and the union. I know the local MP was everywhere in the newspaper talking up a big game, but he didn't front his constituents. In fact, the contribution of the member for Bathurst to this debate in public was to float the prospect of invoking the essential services legislation. And what people thought of that, I will just have to leave the chamber wondering, but certainly it was not a serious proposal. And I note that, given the recent weekend, the Premier had time in her diary to attend the Bathurst races last weekend. Good luck to her. But she had declined an invitation to meet with the council in Lithgow, and she did not have time to stop off in Lithgow on her way to or from that particular fixture, and that is not, I think, acceptable. The behaviour of the government in not addressing this matter with urgency has placed the state's electricity supply in some crisis, at least from the uncertainty it has caused, put more than 600 local jobs at risk, and has failed to address the long-running environmental issue of untreated water flowing into the Sydney water catchment. The bungling of the Berejiklian government over the Springvale mine has put jobs, power and water quality at risk all in one go. Some achievement, Mr Deputy President. The current Premier and her ministry has also left the state exposed to an over-reliance on coal-fired power by failing during its term in office over the last 6 years to support the adequate development of new electricity generation projects for New South Wales. But, Mr Deputy President, it's actually worse than that. Why is the potential closure or interruption of service from Mount Piper so potentially devastating for the state of New South Wales?
Harry Unsworth that.
Well, I'll explain that.
No, order.
Thank you, Mr Deputy President. I'll explain. Simply, Mount Piper currently provides 10 to 15% of the state's electricity. I think it's an average of 11 or 13%, depending on the day. And of course, taking that offline and out of the market, whatever anybody else says, will have a massive pressure, upward pressure on the cost of the electricity and would stretch the system as we head towards summer. But why is it such a problem? Well, as I was there on Monday with the Leader of the Opposition, Mr Foley, addressing the workers, we stood there at the entrance to the mine in the shadow of what had been the Wallerawang power station. This government, those opposite, privatised the Wallerawang power station. Sold it to Energy Australia, who, having purchased the power station, promptly closed it, costing New South Wales 1,000 megawatts of energy, putting upward pressure on prices due to a lack of supply, costing jobs, I acknowledge that interjection, but also making the rest of the state's power supply more at risk of events like what has happened with the mine and with the power station. So the fragility of the New South Wales power system in the situation in which we now find ourselves was brought to us by the Liberal National Party coalition and their privatisation mania.
Absolute rubbish. What even your former Premier thinks.
Order!
Now, on this side of the House, we will continue to reduce the risk to the state by advocating and promoting the rapid growth in renewable energy for the state, as I said, to ensure less risk for our electricity supply by having a diversity of sources, as well as supporting a transition to a clean energy future. This includes supporting the objective of Australia as a whole achieving 50% of its energy from renewable sources by 2030, and other measures both the Leader of the Opposition and myself have outlined in public. And I note the contributions on this particular topic made by my colleagues in the other place, my local MP, the member for Blue Mountains, Trish Doyle, and the member for Summerhill, Joe Halen. And I note the contribution of other Labor members in that debate in the other place. The fact is, we recognise that given the uncertainty caused by the court case and the inability of the parties to sort it out between themselves with a legally effective result, New South Wales Labor proposes a common sense solution to ensure the mine remains open. We support guaranteeing the state's electricity supply. We support securing the more than 600 jobs in and around the Lithgow area, and we support protecting vulnerable drinking water through the acceleration of the already approved $150 million water treatment plant. Only a week or two back on radio, I indicated that if the parties, including the state government and the court, were unable to solve the problem, New South Wales Labor would support other necessary measures. And of course, as a matter of logic and common sense, this included having to legislate if necessary to ensure the mine remains open, subject, Mr Deputy President, to commitments to guarantee and accelerate the delivery of the necessary protections for our drinking water. And we made this clear when we met at their request, the Council and the Union last Friday, and agreed at their invitation to travel to Lithgow this Monday to meet with mine and power station workers and their families. As I had indicated, the Premier had declined requests to meet with the leaders of Lithgow City Council and the representatives of the Springvale workforce, and in desperation they sought the assistance of the Labor opposition. We met with them. Well, isn't it funny? This government sits on its hands for 10 weeks. For 10 weeks, it only talks to the companies, it doesn't talk to the workforce, it doesn't talk to the litigant that brought the case to see whether it could all be brought to a satisfactory conclusion.
As if that litigant...
As soon as the word got out, that the Leader of the Opposition and I were going to Lithgow to address the workforce, to outline our plan to keep the mine open, to secure the state's power supply, the haste, the indecent haste with which this government rushed into the papers on Monday, the announcement that they were going to do something, could not be constrained. But at least late is better than never. The fact is, they should have acted earlier to try and sort this out, and they should have done so openly and transparently with everyone affected, not only the companies involved. It was simply unacceptable that the state's newest and most modern coal-fired power station, Mount Piper, was facing the likelihood of no longer having a supply of coal. And as the leader of the CFMEU, Andy Honeysett, in that region put it, it shouldn't have taken the intervention of the Labor opposition to prompt the government into action. Well, I acknowledge that interjection, but the government had made no comment earlier. The opposition had spoken to the government to ask them what they were doing, but no answer came, the stern reply. And the government certainly didn't talk to the workforce, to the council, or to the other litigant involved in the case to try and sort it out. So the government has announced legislation, but that legislation is not properly focused on simply securing Springvale and Mount Piper as it ought to, but it also proposes reducing important environmental protections that are now in place, courtesy of the Court of Appeal ruling and the SEP, for the assessment of projects being renewed or extended in the Sydney Water Catchment. Now, Mr Deputy President, given that the legislation will immediately address the issues of energy security for the state and the 600 plus direct jobs in Lithgow, the Labor opposition will support these moves by the New South Wales Government. But we will also act in this chamber to ensure there is no reduction in protection for our drinking water. As I indicated earlier, it should simply not have come to this. The state cannot afford to lose more than 10% of its power supply. But the government did it and has now overreached. I understand that the proposals in the legislation have caused some concerns for people in the community concerned with the quality of our drinking water, not only environmentalists but regular citizens. But the fact is, if we shut down or even put at risk 10 to 15% of the state's power supply, community support for environmental protection, strong action on climate change and a transition to a clean energy future would be destroyed overnight. This is about energy supply in the immediate term. It's about keeping the lights on and also about preserving several hundred jobs in Lithgow. And of course, it's not fair or reasonable that the government is trying to invite the Parliament to make a false choice between either keeping the lights on or protecting drinking water. The fact is both are necessary and both can and should be achieved. Energy Australia and Centennial Coal must accelerate the delivery of the water treatment plant they promised because clean drinking water is non-negotiable. Now, the problem, of course, created by the Court of Appeal decision is that even if the court was to delay the implementation of the final orders and to allow Centennial to go back through the planning system, that would take time, would lead to further uncertainty, and it would certainly push back even further the construction of the water treatment plant, which is necessary to protect the water impacted by the past actions of the mine, as well as the future activities that are proposed there. And that is also not fair and reasonable because the companies will not spend the $100 million plus while there is any uncertainty about the approval of the mine, which is just rational. And I acknowledge that. That's absolutely fair and reasonable. So ensuring that Springvale coal mine stays open is necessary, not only to keep hundreds of workers and jobs and the lights on, but also because it's essential for the company to then deliver on its promise to construct the water treatment plant. But as the Deputy Leader of the Opposition in the other place said in the debate on the legislation, the bill should only deal with the Springvale coal mine issue, but it goes further and tries to weaken the legal protections and standards regarding the quality of Sydney's drinking water catchment, and we will oppose this course of action. New South Wales Labor is very proud of its record when it comes to improving the quality of Sydney's drinking water, and we're very proud of our role during our terms in office of building on environmental protections in this state. But if the legislation is passed by this House without the amendments that Labor proposes, the next Labor government will restore those protections to the legislation to make sure that the proper protections for our drinking water are in place. We are committed to reinstating the proper standard of environmental assessment of projects in the Sydney Water Catchment if the legislation is weakened this evening, although we earnestly hope that it is not. This legislation should deal with one matter open, one matter only, ensuring that Springvale coal mine stays open and the supply of coal to Mount Piper remains flowing. We make no apology for supporting the necessary action to keep the mine open, because we understand that while there should be a transition to a clean energy future, it has to be a managed transition, it has to be a just transition, and we will be proposing a transition authority to make sure that no worker and no community impacted by changes in technology or energy mix are left behind. As I said, it's a false choice to try and force the Parliament to choose between keeping the lights on and protecting our precious drinking water. Both objectives can and should be achieved. Playing games, playing politics, using this opportunity as a Trojan horse to try and weaken the protection of our drinking water, as the government proposes doing, will rightly be condemned by the community. But let's just pause to think, to ask ourselves what the government thinks it's doing.
Order. Just allow the debate to proceed without a conversation occurring across the chamber.
Thank you, Mr. Deputy President. As I outlined, I've been reasonably critical of the government's handling of this matter, questioning its competence. But we have to question whether the government actually knows what it's doing or knows what the bill it has before the House actually does. In the Australian Associated Press yesterday, and printed in the Australian today, the Premier has made a contribution to this debate. And she says, and I quote, "The legislation will make sure that the water quality has to be at least as good as what was there before the mine. So we're putting in stringent environmental safeguards, which is a plus for the community," Ms Berejiklian told reporters in Sydney on Tuesday. Well, we agree with the Premier. And those comments from the Premier shows that she clearly agrees with the New South Wales Court of Appeal. But it seems that the bill brought forward by the minister opposite and in the other place don't agree with the Premier, because that's not what the bill before this House does. Now, I'll come to that, because the bill is in two parts, essentially. The first part validates the Springvale development consent, subject to the environmental protections put in place by the PAC, including, as we know, the requirement to treat the salinity, which in a practical sense means invoking the water treatment plant approval. That's all done and dusted in Schedule 1. There is no issue about Springvale or the impact on the water as a result of Schedule 1. So what's Schedule 2 doing? Schedule 2 doesn't clarify the legal test, the Norby test. It changes 34 capital B of the Environmental Planning and Assessment Act and rewrites part of the catchment SEP to get around the ruling of the Court of Appeal. And what will that mean? It means that all the mines operating before 2011 and other forms of development activity taking place in the Sydney Water Catchment that come up either for renewal or for applications for expansion will, of course, have to make that renewal application or expansion application and be subject to the Norby test, which will increase the level of environmental protections required of those activities. But the standard that the Court of Appeal says has to be complied with is significantly higher with the standard that the government says was settled law prior to the Court of Appeal ruling. So what the government is now seeking to do is a special sweetheart deal for the resources industry to say that as you have to renew your projects or you seek to expand them, we're going to put a limit on the environmental standards that you will have to comply with to protect Sydney's drinking water. We're not going to have the standards up here, we're going to have them down here, significantly lower. And that is not fair and reasonable, because the history of environmental protection in this state is one of incremental improvement, that each generation has higher standards than the one before, and that, and this has surely been beyond partisan politics, that the vital drinking water that we all depend upon should have the highest and strictest standards applied to it. But that's not what the government is doing. That's what the Premier apparently wants, but it's not what the Minister and the government is doing. So we don't think Schedule 2 is necessary. It's certainly not necessary to secure Springvale or Mount Piper or the 600 local jobs. And that the government should understand this and should jettison the Schedule 2. And if they think that the standards of environmental protection need to be explored, we'll certainly look into that. But don't rush at it like this. The fact is, so now I'll turn to the issue of whether or not the higher standard articulated by the Court of Appeal should have taken the government by surprise. I've read all the documents I can lay my hands on in relation to this matter. I've read the Land and Environment Court decision. I've read the Court of Appeal decision. The first thing the Chamber should know is that the Court of Appeal is not a bunch of Green Left Weekly activists. Am I sure? I'm asked from the other side. I am absolutely certain.
You don't know, actually, Adam.
I am absolutely certain of that proposition, and in so saying, I do no disrespect to the honourable judges. The President, Margaret Beasley, Justice Leeming, and Justice Baston. I know what the Minister's going to say. But what's quite clear when you read the decision is a couple of things. The Minister referred to the Independent Planning and Assessment Commission. What a load of rubbish. The Planning and Assessment Commission was anything but independent in this process. Interestingly, it gave no reasons for its decision. It wasn't asked for any, but it certainly didn't, despite the magnitude of what it was doing, it just simply issued a 2-page outcome. And it adopted completely all the propositions advanced to it by Centennial Coal and by the Department of Planning. So the court was left with the position of having to infer as to what the Planning and Assessment Commission actually took into account and what it didn't. Now, in the event, that wasn't too difficult because of the document trail. And it was quite clear, as Justice Leeming articulates succinctly and very clearly, is that the decision maker, the Planning and Assessment Commission, simply did not look at the impact on water quality with and without mining activity, both before and after any proposed extension of the mine. To put it in a very simple terms that administrative lawyers like to use, it simply did not do the job it was asked to do by answering all the questions it was asked to do. And that is and when you read the decision, the flaws in the current Planning and Assessment Commission process are laid quite bare. First of all, it doesn't appear to have had the requisite complete independence from the executive arm of government. It seems to have, and of course legally it is really an adjunct of the executive, and of course it didn't produce reasons which could be clearly read and understood and to work out whether or not it was doing its job properly. But returning to the issue of whether or not it was settled law, the fact is the Norby test, as I understand it, had never before been articulated or called into question in a court. So the Land and Environment Court decision and the Court of Appeal decision are the first legal decisions. So it may be true that the Department of Planning was applying it in a way approved of by the government, but it wasn't the test that the law required. And I'm not an administrative lawyer, I'm certainly not a specialist in environmental and planning law, but I just don't see how those mistakes could have been, because the catchment set, Clause 10, which is the test to be applied by the Planning and Assessment Commission, was in almost identical terms as Section 34 capital B of the Environment Planning and Assessment Act itself. The Act requires the form in which the SEP had to be cast. And it was quite clear, I think, what the test was. Now, I understand that the government finds the higher standard insisted upon by the Court of Appeal is inconvenient, and I'm sure that those in the resources industry who are facing having to comply with higher environmental standards for our drinking water as they seek to extend or renew existing developments in Sydney Water Catchment would find it inconvenient to have to comply with that higher standard. But surely when it comes to our drinking water, we should all be insisting upon the highest standards to make sure that there are no risks.
We have the highest standard of drinking water.
Well, I acknowledge that interjection by the Minister, but why is the government walking away from its own SEP and its own legislation? Because the legislation doesn't clarify, it rewrites. The bill the government has proposed here changes Section 34B of the Environmental Planning and Assessment Act, and it rewrites the catchment SEP, or the relevant part of the catchment SEP. You're not clarifying, you're rewriting it, you're changing it to provide on any analysis a lower standard of environmental protection for our drinking water than the standard the Court of Appeal found was in your government's SEP. Because I think I'm right in saying the Norby test was put in place by the current government. I'm not certain of that. It was certainly put in place in 2011, and given that the 2011 election was in March, it's fairly unlikely the previous Labor government would have put it in place. So this is the Norby test put in place, as I understand it, by the current government. The Court of Appeal has upheld it at the highest standard, and now those opposite and the government of this state is proposing to walk away from it and to weaken those protections. Now, we're all concerned with the fate of the coal mine, and we're all concerned with the fate of the mine and the power workers, and we're very concerned for the energy security of the state. And we support the measures that address that. We support most of what is in Schedule 1, and that is all this Parliament needs to do tonight. Schedule 2 goes much further. It actually doesn't affect Springvale and its surrounds at all, because that is all looked after by Schedule 1 and by the environmental protections approved by the PAC and the water treatment plant proposal. Schedule 2 goes to the rest of the Sydney Water Catchment and will have effect far and wide on other matters, other mines, other activities, but not Springvale. So if your motivation here is to secure Springvale and Mount Piper, we do not need Schedule 2. If the government doesn't like the cut of the jib of the SEP or the way in which the Court of Appeal has interpreted it, let's have an inquiry into that, and let's have a proper full investigation and a proper public debate about what form the SEP should be in, not rush this through as the government is proposing, because it's not needed to secure the objectives upon which all reasonable members in this House will agree. So we will propose amendments that strip out Schedule 2 and those parts of Schedule 1 that are dependent upon it. We want no risk to the state's electricity supply, and we make no apologies for standing up for that or for the livelihoods of the workers who are affected. But we will also stand up to protect our drinking water and the integrity of the Sydney Water Catchment. And no matter how this government tries to dress it up, the Court of Appeal has made the first authoritative ruling about what the catchment SEP means. And the government doesn't like it, and you want to weaken it because it's inconvenient. Well, I would invite the government to think again. I would invite the government to embrace the words of its own Premier and the objectives that the Premier says in public she wishes to achieve. And to accept our amendments in the spirit of cross-party cooperation, to work on the objectives with which we can all agree, and those with which we cannot agree, let's look at them with a bit more leisure. So we'll be proposing those amendments, and we'd invite honourable members to give earnest consideration to them and to join with us to amend this legislation, to pass what is necessary and to set aside that which is not, and to protect our pristine drinking water with the highest standards of environmental protection.